We had Energy Future Coalition and plenty of evidence to satisfy it, and the court below, without citing
That is really unfair, Mr. Wall. They were under a mistaken understanding, partly because of the submissions in this case, where you were just complaining in your papers about this rule being in effect only till 2025.
So, Justice Sotomayor, that is part of the mistake that the Court of Appeals made, but its error was more fundamental. When it looked at standing, it should have said, we have Energy Future Coalition. It tells us that we have redressability in the same industry, fuel producers, if the regulation locks them out of the marketplace. It didn't say that. It turned to the evidence. And then rather than on the evidence saying, well, this is more than enough to satisfy cases like Department of Commerce or Alliance of Hippocratic Medicine, it said, not enough here. And what that really amounts to at the end of the day is we couldn't get an affidavit from an automaker who didn't intervene. They sat on the sidelines, they didn't want to participate, and because we couldn't get them to stick their hand up, we didn't have someone saying, here is how I will change my fleet absent the waiver. And that's what we didn't have. And if that's what it's really going to take for an indirectly regulated party to get into court, it's going to be far more difficult to challenge governmental action, and these cases are going to become more expensive and frankly arbitrary, because it will turn on whether the directly regulated industry likes the rule or they don't. And as far as my clients are concerned, that shouldn't matter one whit.